From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court upholds the unusual funding mechanism of the Consumer Financial Protection Bureau in a 7-2 decision. Meantime, President Biden uses executive privilege to shield the release of the audio tape from his interview over his mishandling of classified documents. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. The CFPB is a strange creature in the Washington menagerie. It was designed to be autonomous and insulated from political accountability. On Thursday, the Supreme Court ruled on a second big case over this unusual CFPB structure, this time holding 7-2 in the CFPB's favor. Here's the holding in the majority opinion by Clarence Thomas. Congress's statutory authorization allowing the Bureau to draw money from the earnings of the Federal Reserve System to carry out the Bureau's duties satisfies the Appropriations Clause. Alicia, I'm hoping you can explain that a little bit more. What was this case about, and what does this 7-2 opinion say?
So this is the second time that the CFPB has actually been up at the Supreme Court defending something related to its structure. Recall that in 2010, the Democrats passed the Dodd-Frank Act, which was intended to create this beast that could not be accountable to any of the political branches. So initially, the CFPB's director, again, unlike other commissions or agencies, it had a one-person director, not a bipartisan commission, and he could only be fired for cause, so not at will and by cause, negligence, malfeasance, or something else like wrongdoing. Now, in 2010, this was challenged at the Supreme Court, and the Supreme Court held 5-4 that it violated Constitution's separation of powers by limiting the executive branch's basically ability to control his own subordinates. Now, fast forward, there's a new challenge, and this was the latest one by payday lenders, which were challenging its automatic funding scheme. So the way the CFPB gets its money is unlike any other agency or bureaucracy in history. It derives its funding from the Federal Reserve, which in turn actually derives its funding from bond sales, the securities or the income that it earns on its security portfolio, as well as fees it imposes. So it does not get its funding from any kind of congressional annual appropriations bills, which means that Congress can't eliminate or reduce its funding to try to hold it accountable for some kinds of rules or regulations if it believes it's getting out of control. Republicans have tried to do that with agencies such as the IRS in order to hold it accountable. The CFPB has no such check, so it gets its funding from the Federal Reserve up to a certain limit. What Democrats passed in the statute was $734 million. Adjusted for inflation. You have to remember that this is actually a very tiny bureaucracy, and some of its actual jobs and responsibilities overlap with some other agencies, namely the FTC and the Federal Reserve, FDIC, other banking regulators. Democrats in the Dodd-Frank Act actually consolidated some of the power and put it into the CFPB and gave it actually much more sweeping powers. It doesn't have a bipartisan commission, so it has a single director. He can subpoena documents from these agencies and basically write all kinds of rules without really any kind of due process or the normal procedures that other agencies have to go through. And again, backtracking. So the payday lenders challenged this funding scheme under the Constitution's Appropriations Clause, which says that no money shall be drawn from the Treasury but in consequence of appropriations by law. And the way that at least the Supreme Court, a 7-2 majority, construed this is to mean that the executive agents simply cannot tap the Treasury without Congress's approval. Rather, that they can basically fund agencies in a variety of needs. The president simply just can't go get money out of the Treasury without Congress approving that. But if, let's say, an agency or Congress wants to set up another agency just like the CFPB or have it draw funding from the CFPB, it could do that.
Kim, the importance of this funding structure, and I think this was intentional, is that it eliminates a regular political check on the CFPB as an agency. Many agencies that are subject to the appropriations process end up having to go in front of Congress and justify their budgets and sing for their supper, more or less. It's not unheard of to see very high-ranking officials in the federal government, like the FBI director, even Supreme Court justices occasionally, sitting in front of Congress, making the case for the budgets that they are spending. So the question in this case is whether this kind of workaround that was created for the CFPB, where it can just draw money from the Federal Reserve up to a certain amount, whether that's constitutional. But it does seem to me, Kim, that if the answer is yes, that there will be a push to create more of these agencies that are just pulling money from sources like the Federal Reserve, because that is the way to prevent the other party, when it takes power, from having some control over what they do.
You have put your finger on a really important point, Kyle, which is particularly the nature of what the CFPB does. When you look at the majority ruling here, and it was 7-2, they go back into constitutional history. In fact, Clarence Thomas goes back even farther and talks about fights between Parliament and the King. And he points out that, in the immediate aftermath of the founding, there were a couple of situations that you had agencies that were authorized to expend money in ways that he says are similar to what's happening in the CFPB. But then you read Samuel Alito's dissent, and I think it's really important because he gets to the nub of the issue, is that the reason that we have this appropriations clause is designed to prevent the president and the executive branch from circumventing Congress. And he actually notes that, in fact, for the majority of the history of the country, immediately after the founding, almost every agency has been required to have appropriations for this reason. But he also, and this is your point, points out that one of the examples that Clarence Thomas had given was the post office. Alito notes that this is very, very different. This is an agency that has the ability to put out subpoenas, to issue penalties, that just in recent years has issued some sweeping new changes to rules that they specifically did not go to Congress and get authorization for. And yet, this ruling will essentially allow this agency to do whatever it wants with no fear whatsoever of Congress being able to try to limit it by limiting its funding in any way. And I think this is all the more relevant as we have had in executive branches over the years, especially the Biden administration and the Obama administration, that have been pushing the boundaries of executive action and agency action. We've had Congress often find that the only way it can try to get it to behave is to threaten to withhold funds. Even there's been some threats to withhold funds for specific offices, for specific programs. And essentially this ruling completely gets rid of that. And now, yes, you can bet, especially Democratic lawmakers, if there is further legislation setting up any kind of new agency or attempts to redo some agencies, they're going to be looking to making this kind of funding mechanism, precisely because it will allow Democratic presidents who like to use agencies to essentially issue rules without congressional approval.
Hang tight. We'll be right back in a moment. Welcome back. Alicia, let me get your take on this. I'll start with a bit more from this opinion from the Supreme Court. The dissent from Justice Alito says that the court's holding is that all that's needed to satisfy the appropriations clause is that Congress identify a source of public funds and authorize the expenditure of those funds for designated purposes. So that means that Congress can say, there's the pile of money that the Federal Reserve has, the CFPB, you can have some of it, you can use it for X, Y, and Z activities. And then Alito says this, under this interpretation, the clause imposes no temporal limit that would prevent Congress from authorizing the executive to spend funds in perpetuity. So that's one of his criticisms. But Alicia, do you agree that if this is a model that will work for the CFPB, it's hard not to see why Democrats, when they next want to create an agency or fund an agency or protect it from political control, or Republicans, if they have some sort of goal that they want to accomplish that they don't want to be defunded by the next Congress, would do the same sort of thing. And the more and more that becomes regular, the less and less bite the appropriations clause then has on the activities that these agencies that are ostensibly being funded by Congress, less control, less oversight that the lawmakers actually have over what's going on.
Right. If you read Justice Clarence Thomas's opinion, he's pretty scathing of the dissent and accuses them of misreading history. And I've rarely seen Justice Thomas or read Justice Thomas being so caustic about some of his fellow conservatives on the court. But I think when the practical implications or practical issues where the Chief Justice, John Roberts, Amy Coney Barrett, and Brett Kavanaugh, where they may have gotten kind of tripped up here, is that there are already a lot of agencies that do not get their money directly from Congress and congressional appropriations. They essentially get their money from their regulated parties or banks, such as the FDIC, the OCC. The opinion mentioned the Post Office, Customs Service, FDA actually imposes user fees on drug makers that submit applications to help fund it. And I think the conservatives struggled to distinguish between the CFPB's funding mechanism, since it wasn't actually appropriated by Congress, and these other agencies. And if they strike down the CFPB's funding scheme, does that mean will there be challenges to the others? And they didn't really want to open up that can of worms. But I don't think they necessarily had to. And I think Justice Alito and joined by Justice Gorsuch draw a pretty important distinction in their dissent, noting that even if there are elements that are safe or tolerable in isolation, as in they were referring to these other agencies' funding schemes, in the case of the CFPB, the combination is deadly. And that is exacerbated by the fact that the CFPB wields so much power. It's not just like the, say, FDIC, which is essentially it's a deposit insurance fund, or like the Customs Service or the Post Office, which aren't really regulatory agencies. They're actually more like businesses. And here, the CFPB wields power over hundreds of thousands of businesses across the economy, both enforcement power and legislative power, basically its own power of the purse because it can self-appropriate, but also the power of the sword, to go back to kind of the Federalist Papers. And you kind of need to draw the line somewhere. And by the Supreme Court not drawing it here, it's basically said that there is no limiting principle in the kinds of new agencies that Congress can set up to circumvent the funding scheme. You could see, as you mentioned, Republicans deciding, well, that if they want to create a new agency within Department of Homeland Security to round up a bunch of illegal immigrants, and that's the agency's sole charge, and maybe, well, it could get its funding, again, also like from the Federal Reserve, or could impose fees on perhaps remittances, get its funding from the kind of tariffs. Or there is no limiting principle is the issue. And I think that that's what Justice Alito and Gorsuch tried to underline in their opinion. And I am concerned about the potential, the very practical implications, consequences, because you've seen in Washington, well, one precedent creates another political precedent. We saw this, with the blowing of the filibuster on judicial precedents or judicial nominations, and each party kind of tends to escalate. And so I wouldn't be surprised if at some point Republicans use, in this case, precedent to try to insulate another agency that they may create down the line from political accountability, the same way that Democrats did with the CFPB.
What about the 7-2 split here, Kim? This is somewhat of an unusual lineup. It's an opinion written by Justice Clarence Thomas, joined by the Chief Justice John Roberts, Justices Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson. So 4 of the conservatives there. And then the dissent by Alito is joined by Neil Gorsuch. And often I think there's a caricature of this court as a conservative liberal split, and the 6 conservatives all think alike and side with each other on everything, and the 3 liberals are always in dissent. And I think that is an incorrect caricature of how the court works and the real ideological divides among some of these conservatives. Alicia a moment ago said that she thought the Thomas opinion was a bit scathing toward the dissent. And I think Justice Alito is pulling no punches in his dissent either.
It's an excellent point. Look, the characterization of this court as a 6-3 court all the time is just nonsense, especially when you go and look at the track record of the opinions and the decisions. The Supreme Court issues dozens of opinions every term, dozens upon dozens, and usually there's a handful of them that fall along those 6-3 ideological lines that are the stereotype. And those tend to get the most attention because they're often some very big cases. But that's not normally how the court breaks down. And what I love about this particular fight, I agree with Alicia, I'm much more in line with the dissent here than I am the majority. But what's really fascinating by these dueling opinions, the majority and the dissent, is that they both reach back in history as a justification for their decision. So it also shows to us that those who often are skating about originalism or constitutionalism and the idea of reading textualism, the idea of reading the actual text of laws and looking back to history, it just goes to show that there's a wide variety of ways that you can look back at that too in different interpretations of what you see. That is much more common when you really drill down into the lineups and how people fall in these different opinions. It's much more often that you see those kind of disagreements, and those disagreements happening among the more conservative-minded justices. So just the latest example that those characterizations are silly.